Okay, welcome class. We are having another class on mental health and the law, and it's a brief session to cover for the topic mental health and the law. So, the law is what we use as the basis for operation. And so, for you at this level, at the level at which you are mastering your social work, as regards to mental health and ill health, understanding of the law as regards to mental health is very critical. Okay, so we are going to go through these in brief, but you will have to go to the various laws and be able to understand them fully, critically, and be able to operationalize them. All right. So, mental health and the law intersect in an array of ways. For example, in the consideration or in the safeguards of the rights of persons with mental illness, mental health, and the law consider issues of mental capacity, the ability of the affected in terms of their cognitive capacity, involuntary admission to mental health institutions when needed, and we'll expound more on that, criminal responsibility of the person who is mentally ill as regards to whatever conflict they may have with the law at the time, legal protection from discrimination of a mentally ill person in consideration of their mental capacity. So we must understand the legal frameworks, like I already emphasized, in order to be able to effectively advocate and lobby for our clients. And in addition, in order to operate ethically as we work to protect or to serve clients who are affected by mental ill health within the justice system. So in this case, the two systems are interacting, the health system and the justice system. And understanding of both is very, very critical. Like I always encourage us at this level, already some of you are managers in the institutions in which you work, or upon completing your master's, it will catapult you to managerial positions as regards to your social work practice, which is excellent. So already that will be a plus. But I always tell you, alternatively, is to be able to have impact on the ground, bringing in services that the community is really in need of through your own consultancy or your own initiatives as a business. And you can do that as you're doing your other work as a side hustle, or you can be self-employed as a consultant providing these services. So one of the areas, okay, where there's a gap already is in mental health and the law. And so understanding of the justice system, the legal systems of the land, and the law as regards to mental health is very critical. And once you get that, you can just serve this niche of clients who are mentally ill and are in conflict with the law or vice versa. All right. So, having said that, let's look at the legal concepts in mental health, a few, not all. We have mental capacity, so the ability of an individual to make decisions for themselves. As we know, having looked at the various illnesses, mental illnesses, mental illnesses affect the capacity of the individual to make decisions for themselves, um, to study, to be employed, and so on and so forth, to carry out the activities, the daily activities that will help them progress. So it hampers their progress. So the understanding of this ability is very key. Um, and so we can look at, for example, their IQ, okay, is one of the ways we'll be able to assess that. Involuntary admission is another concept. This is admitting a person to a psychiatric facility without their consent under certain legal conditions. So perhaps where they pose a danger to the community, to those around them, or to society, for example, or where they're involved in a criminal activity that is in addition hampering or affecting the lives or the safeguards or the security of other members of society. Then we have duty of care as another concept. This is the legal obligation of healthcare providers to protect clients and others from harm. And so this duty of care is also um, um, considered for those who are mentally ill. We have confidentiality and consent. Those are actually two terms, but this is respecting the privacy and autonomy of individuals while balancing legal requirements. So, for example, where we have, a suicidal individual, so already they are mentally affected. Yes, they have a right to confidentiality, but it is legally required for us to mandatory report such an incident because they pose danger to themselves. That is a member of society whose life needs to be protected. Okay, let's look at the legal frameworks governing mental health in our country. You have the Mental Health Act of 2022 revised, and let's look at some of its key highlights. So what you will do is you will take time, particularly out of interest in practicing in this area, or already, like one of you know is already practicing deeply in this area. So you take time to deeply understand this act. But some of the key highlights include that it promotes deinstitutionalization, okay, and promotes community-based care. So moving away from using institutions and using the community to rehabilitate those who are mentally ill. It requires establishment of county mental health councils. Now, health being devolved in our country since the new constitution came into place in 2010 through devolution. County mental health councils are required to be established to be the governing bodies that make decisions about mental health issues within the county. Another key highlight, it upholds the rights of persons with mental illness to dignity, informed consent, freedom from torture and abuse. So it really emphasizes on the rights of those who are mentally ill or affected. Another key highlight is the legal provision for involuntary treatment is done only under strict conditions. Okay, so the laws provide for involuntary treatment, yes, in certain circumstances, but only under strict conditions to protect the person or the client who is mentally ill. So, like I said, you need to go through the act itself and understand it in terms of its practicability, the the ability to employ the act, okay, in various circumstances that would affect possible clients or existing clients. Then we have our constitution as a legal instrument. In our constitution, in brief, Okay, it's of course the entire constitution is quite a document, but in brief, let's look at these articles. So within these articles, you then need to go through and look at the depth of the material contained in these articles, and look at the application of the articles. So Article 43 1A, this is the right to the highest attainable standard of health, including mental health. So this gives us the basis to provide the highest attainable standard of health for these clients embedded in the Constitution. Article 54, rights of persons with disabilities, including those with mental disorders. So again, this helps us to protect the rights of our clients who have who are mentally challenged, being a form of disability. And of course, the Constitution provides that right, so gives us the basis to practice. Then we have Article 28, the right to human dignity, which is actually a social work value. So the Constitution, therefore, is in tandem with the values of that particular value of the profession. So, therefore, the Constitution giving us the power and the legal right to be able to practice, including for us as social workers in our profession, in terms of the emphasis of our values. So therefore, let us look at some of these laws in brief. We have the Persons with Disabilities Act of 2003. In brief, this act protects persons with mental illness from discrimination in employment. Okay, so they have a right to employment. From discrimination in education, they have a right to access education, and from discrimination in access to public services. Right. So already, as we move on, we are seeing how the law is strengthening us in the ability to provide services for these clients and to protect these clients in terms of their rights. Then we have the Penal Code. Now, sections on criminal responsibility and fitness to stand trial for persons with mental illness. So the Penal Code is used to detain persons under criminal lunacy, okay, from the word lunatic, okay, crazy. Okay, now this is increasingly contested as discriminatory. Okay, some of the uses of these terms and the discriminations that come with the use of some these terms, because somebody's mental status can be fluid, okay, can improve at a given time or not. And this also leads to labeling. Okay, so there's so many ways that this can be argued. Okay, all right, so let's look at involuntary admission and treatment. The conditions that permit involuntary admission include when the client poses a risk of harm to self, like the example I gave of a suicidal client, or poses a risk of harm to others, to members of society, like somebody proposing to be a suicide bomber. Okay. Again, those who have the incapacity to make treatment decisions because of their mental capacity or incapacity. And the decision is usually made by a qualified health practitioner and then reviewed by a tribunal or a court. So the psychiatrist, for example, will make the decision, and then the court will review that decision and come up with the final judgment. The procedural safeguards when it comes to involuntary admission and treatment include the notification of the next of kin about the admission, let's say, into a psychiatric facility, must be done. The family again can appeal, all right. The decision can be reviewed, okay, and the family can appeal the process, or another institution can appeal. And there are timelines for reassessment. Like we said, mental status is fluid because of medication, rehabilitation. There can be improvement, and therefore, somebody who has been checked into an institution can also be discharged from the same institution because of their improvement in their status. The legal and ethical challenges in practice of mental health as regards to the justice system involve balancing autonomy versus protection. So in autonomy, we're talking about the uh, right of the person to make their own decision. Um, but then also we have protection of their rights, to be able to refuse treatment, for example. So that's an ethical dilemma. So, for example, forcing them to take medication versus their right to refuse. Okay, so an ethical dilemma therefore occurs in that case. And so, based on various circumstances, a decision can be processed using a multidisciplinary approach. Depending on the circumstances, each circumstance is unique. We have lack of legal literacy among mental health workers and the police. So these are the administrators within the mental health provision and within the justice system, and which is what we had emphasized earlier, the importance of understanding the laws, uh, the the laws of the land that affect mental health in depth, and also mental health laws. Okay, so the justice system as regards to mental health. So we have a lack of that legal literacy. So therefore, one of the openings, let's say, that are there for us or for yourselves, is to be able to understand these and provide these trainings to mental health workers and those like the police, those in the legal system, okay, or in the justice system. Um, Another challenge is discrimination and stigma. For example, we have talked about terms that lead to labeling like lunatic that need revision. Uh, you, you know, Generally, we are still dealing with, as we had looked at in previous classes, with the understanding of those who are mentally ill and their families. In our communities. So still we have discrimination and stigma occurring in communities and in society against those who are mentally challenged. And furthermore, those who are mentally challenged are in conflict with the law. And so creating awareness to community members and the society about these matters, and education, providing education and training on these matters is also very critical. And this also opens another door of service that you can provide in your consultancy. Another challenge we face is underfunding of legal aid for mentally ill accused persons. Um, Again, creating awareness among possible or existing funders, including philanthropists. Right? That's again another niche that you can work in. And then lack of mental health costs in our country. So this would involve lobbying with legislators like our MPs at national level and our MCAs at county level, now that health is devolved, to be able to enhance the existing laws and lead to their review to have friendlier laws. Let's look at mental health and criminal justice, and we look at mentally ill offenders. Mentally ill offenders may be unfit to plead or to or to plead or not to plead against criminally. I mean, they may not be criminally responsible due to mental illness.